You know, when we think of civil litigation, we usually picture those classic scales of justice. Evidence goes on one side, evidence on the other, and the heaviest side wins.
Right, exactly.
But what happens when one side doesn't just put evidence on the scale, but they actually buy the scale, recalibrate the weights, and then, hide the instruction manual?
Well, that changes the whole game.
Yeah. Okay, let's unpack this. Because right now, Walmart handles an average of 10,000 pending lawsuits at any given time.
10,000. It's massive.
Right. We are doing a deep dive into a forensic audit of their litigation tactics. And our mission today is to explore how corporate superlitigants use that massive scale, not just to win individual cases, but to completely rewrite the rules of the judicial system that you rely on.
She says that in 17 years on the bench and over 25,000 cases, she's rarely seen such flagrant abuse of the system.
It was very disturbing to see such an intentional course of conduct. It was corrupt.
She's charging Walmart with cheating in court, and she's not the only one. This is one judge. Is there something in the drinking water in Arkansas that says perjury is all right? Another judge. Rarely has this court seen such a pattern of deliberate obfuscation, delay, misrepresentation, and downright lying. True.
Unfortunately for the customer, they really don't care.
Yeah, because with 10,000 active dockets, a corporation just isn't litigating facts anymore. They are, as the audit defines it, playing for rule.
Playing for rule.
Exactly. If we connect this to the bigger picture, it's classic repeat player theory.
Yeah.
Just taken to its absolute extreme.
I've got to admit, I am a little confused by the economics here because the audit highlights them spending over $1 million in legal fees just to fight a $7,000 fine.
It seems crazy. We're right.
Yeah, I mean, from a balance sheet perspective, that makes zero sense.
Well, it makes perfect sense if you view it as a deterrence tax. So by deploying this scorched earth defense against a totally negligible fine, they're signaling to the plaintiff's bar that no claim is ever going to settle cheaply.
Oh, wow.
The goal isn't to save $7,000 today. It's to ensure the next 50 lawyers look at the massive cost of discovery and just, decide not to file at all.
So it's like a high-stakes poker player who aggressively over-raises on tiny, insignificant pots.
That's a great way to put it.
They don't actually care about those specific chicks in the center. They just want to scare everyone else away from the table permanently.
Exactly. And that deterrence tax gets extracted directly during the discovery process. It turns routine document requests into this grueling war of attrition.
Oh, war of attrition.
Yeah, the audit identifies this as hide-and-seek discovery, where the procedural friction is literally the entire point.
Like the Cooker case. I mean, they literally stamped completely blank pieces of paper as confidential.
Which is wild.
Right. It forced the opposing counsel to build a secure double filing system just to process reams of nothing, which effectively doubled their legal costs.
Or look at how they heavily litigated a 2-minute gap in surveillance footage in the Panetta case.
Oh, the slip and fall one.
Yeah. Though it is worth noting here, to be completely impartial, courts don't always view this as misconduct. In that Panetta case, an appellate court actually found Walmart acted in full compliance.
Wait, really?
Yeah, because the plaintiff initially provided the wrong time for the accident. So the line between aggressive legal advocacy and actual obstruction is incredibly thin. And super litigants know exactly how to walk it.
But since courts and auditors are getting better at spotting those physical paper trails, the battlefield naturally had to evolve. And here's where it gets really interesting.
Oh, absolutely. The shift to digital.
Right. They've moved the fight into opaque digital systems. Walmart shields millions of data points, like biometrics and facial recognition, by labeling their internal algorithms as trade secrets.
It's a huge shift.
But wait, I need to push back on this. Isn't that just standard corporate defense? Like, if I build a proprietary algorithm, I shouldn't have to surrender my source code to the public record just because someone slipped on aisle 4.
That's a valid argument, for sure. And it's exactly the legal paradox they exploit. A trade secret designation requires the plaintiff to prove they absolutely need the algorithm to make their case.
Okay.
But how can a plaintiff prove what the algorithm does without seeing it first?
Oh, I see.
It creates a circular trap. To pierce that veil, you need millions of dollars for digital forensics, effectively neutralizing the discovery process entirely.
Which forces plaintiffs to find cheaper ways to keep up, leading to that bizarre AI anomaly in the source material.
Right, yes. In a recent case against Walmart, the plaintiff's lawyers actually tried to level the playing field using an AI legal platform to draft motions.
And it backfired spectacularly.
It really did. The AI hallucinated fake citations. 8 of the 9 cases they cited didn't exist, and the plaintiff's lawyers were the ones who got sanctioned.
So what does this all mean? We're looking at a landscape where blank paper is classified, proprietary algorithms are impenetrable black boxes, and AI is hallucinating case law just to keep up.
It means that for superlitigants, litigation isn't a search for the truth at all. It's a risk mitigation product.
A product, wow.
Yeah. By leveraging procedural delay and the staggering cost of discovery, they basically use the judicial system's own rules as a strategic shield.
Which completely transforms who has access to that system. I mean, if this is the new playbook for winning by attrition, what happens when every Fortune 500 company adopts it?
It's a terrifying thought.
Right. We might be looking at a future where the middle class is priced out of civil justice entirely. And it leaves you with the big question. As AI and algorithmic data make evidence even harder to uncover, who will ultimately write the rules of future digital litigation? The judges or the superlitigants who can afford to outlast them?